morning and welcome. Today, the business of today will be conducted by the CJ and he takes over. Kindly, Council, you are requested to speak at the podium because you can see the other microphones have all been removed, so we are using the podium exclusively for today.
Does everybody have the we've given you? Simply thought that we needed as judges to familiarize ourselves with and material. We thought we needed that exercise. We need to say as judges that you are not doing it to help anybody. And we thought we would share the report with you and invite comments, if any, to be made by the leading councils. A mountain of stuff to do. And it's going to be very, very tough for us. So just give your comments on the reports. And we're going to work very hard to make sure that we don't give the judgment. Regeru. So don't exceed 10 minutes, sorry.
I won't even get there, my Lord, given the nature of these documents. I got them not too long ago, so in terms of detailed scrutiny, I haven't even looked at them to any. Direct comment would be is concerned in the directions that you gave about the scrutiny. There was reference to a category of votes, the rejected votes, and just by a casual glance of the tables that has been given, 5 constituencies have been highlighted in green, queries have been raised, and they do not seem to relate specifically to rejected votes. So as far as our petition is concerned, we would really be going by the finally on the 9th of March. And if you remember, there was a category of rejected votes that came to about 108,000 odd. So, and as I said in my submissions in support of that petition, really no challenge to that figure. That figure does not appear to have been controverted. This scrutiny does not seem to it in any direct way. The submissions that I made as far as petition number 3 is concerned, then you're talking about an adjustment. If your lordships are inclined to grant the petition and you direct that rejected votes ought not to have been factored, then the totality of that rejected vote count, 108,000 odd, would not be factored in, with the result that there would be a corresponding each of the 8 presidential candidates got. And that would be the extent of my comments as far as this table is concerned.
Thank you very much, Mr. Garo. Ms.
Good morning, my lords and my lady. I think the clock should start at 10 minutes, not 7.
The remaining minutes were credited to you.
I'm most obliged. My lords and my lady, we've looked at these two reports very briefly, but what we've seen confirms the allegations in our petition, and that is the first and second respondents did not verify the results from all the polling stations as was required under the law. States briefly as follows. In Laikipia West, according to your scrutiny, they're not able to verify the votes cast. In Githunguri, Form 36 shows two different numbers. Form 34s are missing in 10 constituencies. Form 34s. My Lord, it is my humble submission that under Article 138(4) of the Constitution, for a candidate to be validly declared as president, he must meet 3 thresholds: majority of votes, 25% in more than half of the counties, and over half of all the votes cast. The first and second respondent were under a responsibility to tally and verify the results in 33,400 polling stations. The formula in Article 138(4), my lords, is mathematical. There is a constant, and the constant is, my lords and my lady, all votes cast. All. If, my lords, there are Form 34s missing, we have to ask yourself, where are these Form 34s? This election was conducted Even if the presiding officers were walking these forms to Nairobi, by now they would have reached. My lords, this report confirms that the returning officer of the presidential elections made a decision without completing the tally of the results from the polling stations. There can be no Form 34s, even if it was one. Even if that polling station had one registered voter, like Charity Primary School had, the chairman of the Independent Electoral Boundaries Commission could not announce the result without having that form in his hand. My lords, it is my humble submission that this court is not simply an adjudicator. You also have the power, discretion, jurisdiction, and responsibility to audit the results declared by the Independent Electoral Boundaries Commission. My lords, even for this 10 constituencies, can this court state with certainty what the results of those constituencies were for the presidential elections when Form 34 is missing? And I'll take you back to the submissions on behalf of the first respondent, second respondent, third respondent, fourth respondent. They told you yesterday that voting, counting and tallying of the presidential election results was at the polling station. And the presiding officers filled in Form 34, and in 86% of the polling stations it was signed by agents of the petitioner in petition number 5 of 2013. And the responsibility of the first respondent and second respondent was to verify those forms. My lords, where are those forms that came from the polling stations? It is what must address itself to Article 138(4) and the results of this scrutiny, and ask itself when the decision was made, when the declaration of that decision was made, was the formula complete? The constant, all votes cast, had that constant been met from the records that are before you? And when your own report says that the votes from a particular constituency cannot be verified, and in that constituency, my lord, like Laikipia West, we've checked the declaration of results. The president-elect got 70,760. And the result of that constituency cannot be verified. My lords, did the IEBC carry out its mandate as required by the law and the Constitution? And can the decision of the returning officer of a presidential election be upheld by this court? Of those critical election materials. That is all, my lords.
Senior Counsel Oraro.
My lords, I would begin by saying that the court, having now ordered a scrutiny, the results of the scrutiny override the information which we have given in respect of the issues we have raised, because this is as a result of the investigation by the court. The objective of the scrutiny was, one, that there shall be a scrutiny of all Form 34s which were used by IEBC, and the scrutiny shall aim at establishing the number. And importantly, that there shall be a scrutiny of all Form 36 which were used by IEBC in aggregating the tallies of votes. So I will begin with the scrutiny and state that the report we have been given does not throw a lot of light on this scrutiny. It is found at paragraph 3, and it lists about, I think, about 7 constituencies. So there is no scrutiny from all Form 36s. And even in respect of those 7 constituencies, you find that there are grave errors in Form 36. And in respect of constituencies, there are 2 Form 36s. Copy of the first form, registered voters not indicated. Form 36s with varying number, 36s with incomplete figures like in Malava. So what this shows you is that there was a huge discrepancy with the Form 36s which were used to tally the final report. But the most important scrutiny in respect of this is the scrutiny in the 22 polling stations where we have got a report. Now, according to your order, this scrutiny was supposed to be based on the registered voters as indicated in the principal register, and that was in your order number 7. However, the scrutiny has been carried out taking into account, if you go onto the document we have been provided with, the registered voters with biometrics, registered voters without biometrics, registered voters as per the Green Book, and then they have finally taken into account the variance which registers. At the end of the day, you will not be able to determine what are the number of registered voters in respect of each of the registers against what was reported to be the total number of voters who voted for presidential elections as reported by the first respondents. Done on the report of these 22 polling stations. However, discrepancies along the lines of the petitioner's grievance have been proved. E.g., the variance of registered voters in Form 36 against Form 34 in the 25 polling stations shows that there is a variance of additions of 6,139 voters and subtraction of 12,530 voters when you tally all the figures which have been reflected on that sheet. So there's that huge variance. Further, when you look at the variance between votes cast in Form 36 and Form 34 in 6 electoral areas, and you will find that in you will find that there are additions of 3,347 between Form 36 and Form 34, and subtractions of 4,609. That was the basis of our argument on registration. Entry number 7, and there was additional 5 people after the, and this is just observation from 1 polling station. What does this show? This shows that even after the registers were closed, there were still registrations. We talk about Green Book, but before this court. Further, the register of voters without biometrics has also not been produced before this court, although it was being considered in the process of this tallying. I will now come to section. Will note that the report says that there were Form 34s missing in some polling stations, including the following. They have listed 10 polling stations, but they have not listed the total number of missing Form 34s on the document. Neither ourselves or this court have been provided with all Form 34s. And this is merely from examination of a little more than 18,000 polling stations, not all the polling stations. In the result, what are we saying? We are saying that you cannot rely on the results as provided by IEBC, because even from the examination of only 25, that is the number of polling stations. You have this variation of addition of 3,347 voters as from 4 and 36, and subtraction of 4,639 voters between Form 34 and 36. And you also have, on the remarks, polling stations where who are registered at law. Where that happens, the law requires that the total votes cast in that polling station ought not to be considered. Therefore, when you retire to look at your decision, my lords, I would like your lordship to look at this form very critically, what has been reported to you in respect of 22 polling stations. I would also wish to request you to look at what was the variance in the votes cast at the polling station as was reflected in Form 36, as was contained in the first affidavit of Janet Ongera, and taking the total number of variances which are reflected purely from what you have. I would like to submit that you will find that the consequence is that the total is well above the threshold which has been set up by the Constitution, and that is 50 plus 1, even on that evidence alone. I do agree, my lord, that in my submissions I did give you some documents. I'm just finishing in 1 minute. I did point out other polling stations. I did point them out. And for that purpose, I would not rely on those figures, but I would rely on the figures on the original affidavit. Thank you, my lords.
My lord, your permission, both for the first and second respondents, and in order to save time,
Yes.
We have decided that Nani, our figures man, will address the court.
Thank you, thank you.
For both first and second respondents.
Thank you.
Thank you, my lords and my lady. We have had a look at the scrutiny report, and like everybody else, we weren't able to have a detailed look at it, but it is my humble submission I've taken in this case. My lord, the scrutiny report highlights some apparent discrepancies between Forms 34 and 36. And these have been summarized. The 5 polling stations that have been summarized. Lomerimeri, evidence, answering each and every one of those. So when you retire, my lord, and look at this scrutiny report, you will find that, for example, with the first one, Lomerimeri, we had filed responses. There was the affidavit of the returning officer, Bernard Mokaya, and also the affidavit of Immaculate Kasait at paragraph 26, which explains what that discrepancy is, and when it is explained, you see it is not a paragraph 36, Mogomoini, the affidavit of Wario Ibrahim Ali. So for the apparent discrepancies, they are this was similar to the case that I talked about of Tarbo, where an entire street at polling station, but are indicated in the different one. So for NCC Social Hall, the confusion was between NCC Social Hall and Ngong Forest. Two polling stations in Karen Ward. People designated NCC Social Hall, and it is in our submissions. They designated NCC Social Hall, but the final poll book, the printed register that came out, showed them as being required to vote at Ngong Forest. So for NCC Social Hall, all you need to look at is, you will see there are 4, but they are supposed to have been 5. But when you go to Ngong Forest, which is supposed to have 4, it has an extra is given. And you will find that the second issue highlighted in the report is the of 34s. And my lords, I think we need to make a small distinction here. The Form 34s that were provided in this court was provided voluntarily by the first respondent, not in response to anything. When we filed our Form 36s, we also put in the Form 34s. But before we did that, we had availed to the petitioners all the Form 34s. My lord, we recognized that we had omitted in filing our Form 34s, some of the ones that are indicated here, and they were brought subsequently. But the point to note is that the Form 34s used all of them. And if it is true we had not used Form 34s for these particular 10 areas, the petition of the petitioner would have pointed it out, but it didn't. So you will actually find that we subsequently provided them. My lord, just to give you the context, when we were served, we had 3 days, and we spent 2 days without sleep with 200 people compiling all the Form 34s, trying to check that we have each and every one of them so that we could deliver them. Is there likely to be an omission in that process? Yes. Did we? All of them are there. The other issue that has been highlighted is that in some instances there are 2 Form 36s. And again, the extra Form 36s were provided by us. It's not somebody who said, you've provided this one and here's the other one. And in our explanation and our replies, we explained that the way we read the Constitution, Article 138, is that as a preliminary or provisional tally on Form 36, but the authority to do the final verified bombers. So the returning officers brought provisional Form 36s, and some of them had made errors in those ones. In discharge of its duty under Article 138, the first respondent retaliated, but instead of just giving the court the final one that was used to declare, we also brought the initial one. What error had these people picked up? And when you retire to look at the Form 36s that we provided, we not only provided the first one that had an error from the constituency, but notes indicating what verification was done. So when you have two Form 36s, it is not because there is any mischief. It's because we've been candid and shown you we took our responsibility to in the record. So there was also has been repeated, I think, twice. My lords, in every instance where there was an allegation that there were more votes cast than registered voters, and it was our response that we used the Green Book for purposes of allowing a person to vote, that particular Green Book was exhibited in an affidavit of the returning officer. So this court does have, for purposes of, in addition, when the court asked for this scrutiny to be done, we provided thousands of Green Books to the scrutiny team, so that if there was any issue they needed to check, they would be able to use it. So again, it isn't correct. The last point I would wish to make, my lord, is that, and I am not in any way suggesting how the court ought to use the scrutiny, because it was the court that asked for it, and it is the court that will decide how to use that report. But I think, my lord, we need to distinguish scrutiny as provided for in the rules and the sort of scrutiny that the court asked for. The rules do provide specifically for a scrutiny, and if a party had applied for a scrutiny and it had been undertaken in accordance with the rules, then it would be correct, as my learned friend Mr. Oraro said, that the scrutiny reports would supplant whatever else that had been done. But that scrutiny would have required the methodology that is in the rules. But I think that, and this is my personal opinion, and your lordships will have your own view, that this scrutiny does give some illumination, but I don't think that it is going to be taken as the sort of detailed scrutiny that is provided for in the rules. So in summing, when you look at the scrutiny reports and when you look at our replies, you will find that, in fact, we have been and that there was no breach of the law. And the last point, numbers. In Kapenguria, and we say this number, and Kapenguria, again, as I said, was a good case. And if you have one here, we should delete all this. Let's remember, behind each of these position. So it's not enough to say that having done a desktop analysis, I think that there was one person extra, because in Kapenguria, on account of a desktop analysis. Behind these numbers are real people who made real decisions, and we need to give the weight of their vote that.
Mr. Rebello, is he here? So, Mr. Nyaoga.
No, my lord, Nani was.
Oh, you covered. Yes, sorry. Sorry. So I'll go to Gatia. What? No. That's Mr. Keegan.
Thank you, my lords. I'll start off with the first document that we were given, which is headed Petitions 3, 4, and 5 of 2013, is a 2-page document. That's the first one that we were given. In respect to this, my lords, stations and the comments made in regard to 5 of them. My lords, this is an exercise that was generated fairly quickly, the retiree, and as regards what is flagged, our comments are as follows. NCC Social Hall, the votes indicated as 3,847, and the votes cast did not omitted 5 streams, and the tally left out 1 stream. The tally done pursuant to this honorable court left out 1 stream. And the fact that that was left out, my lords, because this was in response to, or the tally was in response to the complaint in Janet Ongera's affidavit, we had responded to this in Winnie Winfred Gucci's affidavit at page 615. So that should not be used against either party. Actually, the retiree left out 1 stream. There is another polling station, my lords, I think it's pronounced, is it Buri? Yeah? I'm challenged. Boron. In respect to this, my lords, the Green Book, the number of registered voters in the Green Book are 200. And this again is confirmed in Nguchu's affidavit, also at page 614. The so-called error, my lords, has been responded to, and there's nothing as which can be referred to as a discrepancy. The next one is Rimeri. The registered voters were 68. A wrong form was used, a wrong form 36 was used, and that is explained in Guchu's affidavit at page 614. When you read that, my lords, you see that both forms 34 and 36 match figure by figure. All the this is more nearer home, Mugumoini. Registered voters, my lords, should be 241. The votes cast are 211. Again, everything is accurate, and we suspect the retiree by this honorable court used the wrong form 36. There is the distinct possibility that the retiree, pursuant to the order of your lordship, may have used the wrong form 36. And again, in the fullness of time, please look. I turn to the second document, the report of scrutiny. I listened to the explanation by IEBC regarding the complaint or not really a complaint, I'm sorry about using that word, it's not a complaint, but the indication that form were missing. I listened to nothing useful to add. Or that I could say, it's really possible that all those forms were provided but were not made available to the team that was doing this exercise. Indeed, all these forms 34, my lords, there's nothing mysterious about them. They're in the website of IEBC. Parties, we were given a soft copy of all the forms 34. So as regards the first category, my lords, that category of missing forms 34 does not really apply. We go to the second category, which shows or indicates discrepancies. My lords, you notice at a glance that these constituencies are spread across the entire country. And understandably, our young brothers and sisters all over the country who are undertaking this massive exercise on our behalf may have made one or two clerical errors. Or no advantage that can be attributed error that have made voted for our brother or voted at Mathioya. No mischief can be attributed to such clerical error. So in all, my lords, I conclude by saying the advantage but from this exercise and a trend, the trend being that in substance, in material substance, voting, counting, and tallying of votes was carried out to a very high degree of accuracy. And at the respect, it's Good Friday for us. That is all that is required to show that the exercise was, to a very, very substantial extent, possible. And it was carried out for the purpose of trying to show who could emerge the winner in the contest. Although I still have 1 minute, I'll be willing to donate it to court.
Mr. Keegan, you have the last word.
My lords and your ladyship, our first observation is that the two reports that have been filed to the court do not in any way support the petitioner's case. The contents of the two reports as being, number one, the Makueni constituency that was specific to support the arguments made by the petitioner in petition number 5, being that there are instances where the votes were more than the registered voters. And my lords and your ladyship, we therefore submit that the material engage in a scrutiny does not support the petitioner's case. The second issue we wish to say, my lords, is that the fourth respondent was able to access all the Form 34s, which is consistent with the submissions made by the representative, the counsel for the first and the second respondent. And to that extent, my lords and your ladyship, we submit that much as the Form 34s may not have been immediately indeed not an available issue to argue that there were any missing Form 34s, we submit that as an absolute, for all Form 34s are available. The third argument we wish to make, my lords and your ladyship, is the issue relating to these. There are quite a number of It is our submission, it is our observation, my lords and your ladyship, that before would have been more informed and more relevant and useful if the team that was doing this to state if in fact there is more than one Form 36 signed by the returning officer responsible for presidential elections. My lords, it is our observation that every instance where it is alleged that there is more than one Form 36, it is not indicated whether it is signed in more than one instance by the submission in respect to every Form 36. There was only one Form 36, which was signed by the returning officer, the chairman of the Electoral Commission, the second respondent in this petition. And so those comments on the margins of the second report that there was more than one Form 36 should be read against that consideration of the law. We also submit, as was stated by the counsel for the first and the second respondents, that in fact, under Regulation 83, the word confirm and the word verify is used in the regulation that the returning officer was entitled to countercheck by way of confirming and verifying before he could sign and take responsibility for those Form 36s. My lords, we disagree with the counsel for the petitioner in petition number 5. The scrutiny that would otherwise be by the Electoral Commission. My lords, we say that for three questions. The first one, my lords, is that if there had been a scrutiny within the meaning and the intention of the Elections Act 2011, all the parties would have been given an opportunity to be heard to explain some of the issues arising in this, some of the issues that are that would have would be number one, all the Form 34s would have been availed to you. Number two, it would have been explained that the only authoritative Form 36 is the one that is signed by the competent returning officer. And my lord, most, at least up to 90%, presumably, of what you have as observations would not be there by way of affording all the parties the natural justice right to be heard on the issue. And so, my lords, we submit that it does not supplant. We also say, my lords, that in considering the value of the observations made by your scrutiny team, you do take into account also the context and the circumstance that they were under pressure in terms of time. Two last observations we want to make, my lords. The first, the second last is looking at all the material that has been supplied to you by way of comments, we submit, my lords and your ladyship, that there is plans the second respondent discharged their responsibility securely. And we therefore pray and submit, my lords, that you do find and agree with this scrutiny report, that our submissions all along and our response to this petition, that there was substantial compliance. My lords and your ladyship, was it expected and 100% compliance? We submit, my lords and your ladyship, to be errors, mistakes, and oversights. Those mistakes, errors, and oversights, my lords, are insignificant. There was substantial compliance. And suggest that there was malice or ulterior motives or a collusion between the first and the second respondent on the one hand and the third and the fourth respondent, as the petitioner had said. And for those reasons, my lord, we submit that even where you find that indeed there was failure to comply with the rules and the regulation 100%, that is allowed by the law, provided you are satisfied that there is substantial compliance and that there was no ill motive. I reiterate what was said by my learned senior on behalf of the third respondent, that the errors where they exist cut across the country. It was not sectional, it was not regional. For all those reasons, my lords and your ladyship, we submit that the scrutiny report has vindicated the respondent's response, and that the petition does not lie.
Keep your open, because we don't know when we are going to summon you tomorrow. But we'll give you sufficient notice. I'm sure all of you will be in Nairobi. Sleeping most likely, because you've really done, you know, great work, and we'll appreciate you in our judgment when we come to it. But we must say, all of us were very, very, very happy with what came from the bar. And I was asked anywhere outside this country what our bar is like. It's one of the best. It's up there, and so we're very happy. You've helped us a lot. So we now proceed to go and start writing our judgment, and we meet here tomorrow, inshallah. Thank you.